Welcome everyone to this afternoon's hearing of the House Committee on Judiciary and Hawaiian Affairs here on Wednesday, February 14th, 2024 at 2 p.m. in conference room 325 and also via video conference. The hearing is for the purpose of considering numerous measures, and for those who are testifying today, I would request that you keep your testimony to 2 minutes if you can. I'll ask you to summarize at that point. And if you're testifying via Zoom, please keep yourself muted and your video off while waiting to testify, and then again after your testimony is complete, mute yourself and turn your video off. If you need to communicate with the technical staff, please use chat function for that purpose. If you're disconnected for some reason, don't panic, just rejoin as soon as you can, and then I'll try to fit you in so you can provide your testimony when you come back. If power goes off in the building here and we have to cancel this hearing, we will reschedule the hearing or schedule a meeting for decision making, and we will post appropriate notice at that time. If you're on Zoom providing testimony, please avoid using any trademarked or copyrighted images. That kicks us off of YouTube, and that is unhelpful. Please conduct yourself with aloha, no profanity or uncivil behavior. We are all in this together, working as allies for the best purposes of the state. It's okay to disagree, but let's not be disagreeable. Okay, first up, we have House Bill 1901. This is relating to historic preservation. It amends the definition of historic property for purposes of the Historic Preservation Program, exempts state projects on state-owned buildings from State Historic Preservation Division review unless the affected property is more than 100 years old or on or being added to the Hawaii Register of Historic Places or National Register of Historic Places. It requires the Department of Accounting and General Services to conduct a comprehensive survey and inventory of all state-owned buildings within 5 years to evaluate and nominate potentially eligible buildings for listing on the Hawaii Register of Historic Places or the National Register of Historic Places. It appropriates funds. First up, we have testimony from DLNR.
Aloha, Chair, members of the committee.
Aloha.
I'm Adam Downer. I'm the administrator of the State Historic Preservation Division. The department stands on its written comments. And to summarize those, we think that giving an exemption to state agencies for state projects and state buildings is, undercuts the whole purpose of the state preservation program. The state should be a leader and not exempting itself from preservation requirements. Likewise, changing the definition of historic property to 100 years and listed in the Hawaii Register or the National Register of Historic Places. The 100 years, excludes such things as statehood and World War II, which I think most of us would agree are historic events. It also excludes almost the entirety of the careers of Hawaii's most renowned architects. And I have another comment here if I can find it. We do think a survey is a good idea. The state has never conducted a survey. No state agency has been required to or funded to do a survey. And one of the consequences of that is that only a handful of state-owned buildings are actually listed. Among the buildings, for example, which are not listed is the Capitol itself, which I think, whether or not you deem it an architectural masterpiece, it is certainly an iconic representation of statehood. I'd be happy to answer any questions.
Thank you very much. We have testimony in opposition from the Society for Hawaiian Archaeology. Testimony in opposition from NIOP Hawaii Chapter. Mr. Evan Oy, please proceed.
Aloha, Chair, Vice Chair, members of the committee. Evan Oy on behalf of NIOP Hawaii. We respectfully stand in opposition to this bill. Particularly, our opposition is to the expanded definition to include Native Hawaiian cultural practices within that 50 years definition portion, primarily because this essentially broadens out the definition to include various amounts of projects or potentially various amounts of projects, which could add to the potential backlog that's currently, happening at SHPD, which is, holding up vital housing and infrastructure projects that residents of our state greatly need. So as an alternative, we feel as though the language of HB 2261 is more suitable. That one would actually allow the definition of historic properties to include properties on the Hawaii or National Historic Registry. So there is a qualifying process that has criteria that's more than just age, as well as buildings built or constructed prior to statehood day, and that would include and address some concerns with not including buildings that were built before statehood, which are actually truly historic. I think the concept of the bill is to narrow the scope so that that SHPD can review truly historic properties rather than the housing stock that is aging into 50 years old that would be brought under the historic definition and essentially have to go through review at this time. So you respectfully oppose this measure, and thank you for the opportunity to testify, Chair.
Thank you. Next, we have testimony in support from BIA Hawaii, Stephanie Sakamoto. Next, we have testimony in opposition from Historic Hawaii Foundation and testimony in opposition from Ted Bolin. Is there anyone else here wishing to testify in HB 1901? If not, questions, members? No. Question of Evan Hoy. Could you look at, I appreciate your reference to another bill, but I'd also request you to take a look at bill that we were considering last session, mentioned in the DLNR's testimony. We took HB 201, HD2, SD1 all the way to conference. It did not come out of conference, and I don't know if you remember that bill, but I think if you could take a look at that bill and see if that's something that you think moves in the right direction. So I guess nothing, if you don't remember it, don't comment on it now, but go take a look at it.
Actually, Chair, I do recollect
Okay.
that bill, HB 201. I think that measure actually started off at 100 years and then was amended throughout the process to essentially, it does a register of Hawaii or Native Hawaiian or Native Hawaiian ethnic groups. And I think that definition we found as also would be a little bit too broad. Limiting the definition to Hawaii historic places of registry would be, I think, a little bit more tailored of an approach and still capture truly historic properties because they have to apply and they have to meet the criteria in order to be put on the registry. And at that point, there is a balance to be struck there. And we felt as though the language in HB 2261 now is more preferable than 201.
Okay, thanks for that input. Any other questions, members? If not, thank you very much to the testifiers. Always good to see you, Mr. Downer, Dr. Downer, excuse me. Next, HB 1529, relating to burial councils. This measure allows any burial council member whose term has expired to continue in office as a holdover member until the member's reappointment to a second term is confirmed or a successor is nominated and appointed, provided that a holdover member shall not hold office beyond the end of the fourth regular session of the legislature following the expiration of the member's term of office. First up, we have testimony from Dr. Downer of DLNR.
Aloha, Chair, members of the committee. I'm Alan Downer, the Administrator of the State Historic Preservation Division. The department stands on its written comments. And essentially, while there is a real serious problem with finding nominees and appointees to the committees, to the burial councils, the current law already allows people to serve 2 full years after the expiration of their term. It seems to us that 4 years is just too long.
Thank you. Next, we have testimony from Scott Fisher in support. Anyone else wishing to testify on 1529? If not, questions, members? Real quick question for you, Dr. Downer. You do have this discretion to continue for 2 more years. Have you had to use that discretion regularly?
Yes.
And what do you think is the cause for the challenge of getting people to serve on the burial council?
I think there are 2 challenges. I think the first and perhaps the most difficult challenge is that the work of the burial councils can be very fraught. And I think a lot of people find, look at the burial councils and what they deal with and feel like they don't want to take on that level of stress. It's not that they don't think the issues are important, they just don't feel that they can handle it. And we've had any number of people tell us, honestly, we go out and try to find people. And we've had people tell us, look, I watch the burial councils, I can't be in that, I just can't. The other issue is more nuts and bolts administrative. Despite what the law says, so example, OHA is supposed to send a list of potential nominees. We're supposed to provide a list, and both of those lists go to the governor, but Governor Ige and Governor Green, their view is there is one way to get nominated, and that's to apply through their boards and commissions website. And even though we remind people that that's the only way to get nominated, we still have people who tell us, well, I said OHA, I wanted to be, considered, and it's like, we appreciate that, but you have to apply to the governor's website, and that seems to be a real stumbling block. And I don't quite know why. I sat down once after I'd had this conversation and just did a dummy application to a board, and it took me about 5 minutes. So I don't, other than people, and I will tell you that we tell people over and over again, you must apply through the governor's website. And it still seems to be a stumbling block.
That's interesting to know. Thanks for letting us know those two challenges. Other questions on HB 1529? If not, we'll move on. Thank you very much to the testifiers. Next measure, HB 2806, relating to opioid litigation proceeds. This measure establishes the Hawaii Opioid Litigation Proceeds Special Fund and establishes the Hawaii Opioid Litigation Proceeds Council to administer the special fund, establishes standards for expenditure of opioid litigation proceeds received by the state, and establishes and appropriates funds from the Hawaii Opioid Litigation Proceeds Special Fund for 3 full-time equivalent positions. First up, we have testimony from the Attorney General. Welcome. Please proceed.
Welcome. Good afternoon, Chair Tarnas and members of the committee. I'm Michelle Nakata, Deputy Attorney General. Thank you for the opportunity to testify. The Department of the Attorney General provides the following comments. This bill would establish the Hawaii Opioid Litigation Proceeds Council to ensure that proceeds received by the state are allocated and spent on substance use abatement and treatment, and establishes the Hawaii Opioid Litigation Proceeds Special Fund. The Hawaii Constitution places responsibility for enforcing state law squarely within the executive branch. Paragraphs 4 and 5 of subsection C of this bill, however, requires 1 member of the Senate to be appointed by the Senate President and 1 member of the House to be appointed by the Speaker of the House to the Council. These direct appointments by the legislature's leaders appear to be subject to challenge as being in violation of the separation of powers doctrine, because it grants the legislature the power to appoint members to a council that exercises primarily executive branch function. Here, the council will be making decisions on spending of the opioid proceeds. To resolve this issue, we suggested language in our written testimony submitted. We also suggested that the bill be amended so that the 5 community members to the council are expressly appointed by the governor. Thank you for the opportunity to testify.
Certainly. Thank you very much. Next, we have testimony with comments from the State Department of Health. Welcome. Please proceed.
Good afternoon, Chair Tarnas, committee member. Grant Gaventer from the Department of Health, Alcohol and Drug Abuse Division. The department stands on its written testimony and proposed amendments, but if I could, I'd just highlight a couple issues. We understand the intent of the bill is transparency and accountability and expedited use of the funds, but we are making progress. It's been about a year, and we have some concerns about the bill which relate to the progress. The bill would create another council The bill, as written, doesn't acknowledge that there is one that exists already, and it doesn't reconcile that there would be now two councils to interact with, and therefore more work, more paperwork, more meetings and of that nature. And the concern would be that that would slow down some of the progress. Secondly, the bill details how to spend the money, but it doesn't specifically reference the master settlement agreement, which is lengthy and extremely detailed, more so than even the bill. And so there potentially could be conflicts with what is written in the master settlement agreement between the state and the counties versus what's in the bill. And then maybe the third critical point would be the potential for conflicts of interest, as specifically related in the bill. It talks about appointing an individual from the substance abuse treatment section. Because the funds are likely and really will be used in some respects with members of that subject area, treatment providers, there's an inherent conflict of interest. The bill references a conflict of interest, but essentially that person, that representative, would pretty much have a conflict of interest in potentially any matter where funds could be allocated to their to the faction or group that they represent. Thank you.
Thanks. And you have recommended amendments to address those concerns?
We have, mostly it would be limiting the terms in the bill so that they wouldn't conflict with what's in the master settlement agreement.
Okay, but that is in your testimony as suggested amendments?
Yes.
To address your concerns?
Yes.
Okay, great, thank you. Appreciate the work that went into the testimony and your recommended amendments.
Thank you.
Next, we have comments and testimony from the Department of Budget and Finance. Next, we have testimony with comments from the Tax Foundation of Hawaii. Next, we have testimony from the Hawaii Health and Harm Reduction Center. Next, we have testimony from the Hawaii Substance Abuse Coalition. And testimony from 5 individuals: Aaron Ruddick, Thaddeus Pham, Beatrice Zovich, Jason Yaris, and Christine Kapi'ioho. Anyone else wishing to testify on HB 2806, House Draft 1? If not, questions, members? Yes, Representative Gannon.
To the Office of the Attorney General. Good afternoon.
Good afternoon.
I'm not sure, maybe this might be better answered by the Department of Health, but just checking in, with state agencies here. Clarifying, how much money are we talking here coming out of this settlement?
I would want to defer to Department of Health on the exact number in the fund right now.
The committee report and the bill says 156 million. Does that sound about right?
I think that's a total number, but not all of our money has come in. So again, I would defer to the Department of Health on how much money we have actually gotten into the state from the opioid settlement litigation.
All right. Many of us who kind of track policy stuff are totally supportive of the state's use of the tobacco cessation fund and the way that the state of Hawaii has resisted plans like put in place by other legislatures around the United States to use that tobacco cessation fund and settlement money and put it towards other things, roads, potholes, a variety of things. What kind of safeguards can we put into this bill to ensure that the success that we've seen with the tobacco cessation fund is seen with this fund?
There are some safeguards already in the bill. It's supposed to be for opioid abatement services. So there is language that I believe the Department of Health did propose that aligns it to the agreements already entered into as far as the appropriate uses of this opioid proceeds.
How long will it take to take this fund, develop interest from it, and then move that out to appropriate healthcare providers? I'm assuming we're going to use the nonprofits that are already doing this kind of work in communities to assist with all the diversion things that we're talking about in here?
I would want to defer to Department of Health. They have been working on getting contracts executed already from the fund, but I would defer to them.
Okay. Maybe one more quick question. It says in the title, opioid litigation proceeds. A lot of us who do criminal justice stuff, we realize that unfortunately the drug of choice here in the islands, the hard drug continues to be methamphetamines. Can we utilize the proceeds and the services that we want to do with this kind of thing towards those services?
Again, it goes to the definition of the uses of the fund, and it should be for opioid treatment and abatement, but there is language regarding co-occurring mental health and substance use disorder. So it would be covered, but it is primarily for opioid use abatement.
Can I follow up with the Department of Health, if that's okay? Good afternoon.
Grant Gavender, yeah, go ahead.
Yeah, thank you very much for your amendments to the committee. A lot of us are worried about this large pot of money going towards other uses in the state, especially in a year like this year where we might be looking at a budget deficit, as other states have done. Are you satisfied with this bill that it creates safeguards around prospective sort of legislative overreach by future bodies?
So I first would say that sounds like a legal question in terms of what is lawful for the legislature to do. And for clarification, I put my law license inactive because I was with the Attorney General's office last year, and to be in this position, I've gone inactive. So I'm not going to give a legal opinion on that very important question. But in terms of where the money is now, it's in a DOH trust fund. So arguably, the legislature doesn't have access to that as it currently stands. If it goes into a special fund, then I mean, truthfully, you're the experts on that, or the Attorney General's office, as to whether that money could be reallocated. But the caveat to that is the master settlement agreement is lengthy and very specific as to how the money can be used with the counties. And if, arguably, if the state were to deviate from that, then there's potential for clawback from the pharmaceutical companies or the defendants in terms of misuse. So, again, these are legal questions, but misuse of the money could result in further legal action and tie up the money, perhaps, in ongoing litigation.
One more, Chair. So I'm going to continue the other question that I had for the Office of the Attorney General. Drug of choice, the hard drugs of choice here in the islands continue to be methamphetamines. Can we use the services that we want to provide, like through this bill, for methamphetamine users in the same way that the Tobacco Cessation Fund is used to stop vaping? You know, it's like, it's related. We didn't see it coming in the 90s when we created the fund, but it's certainly useful now, and it's useful that we have these positions.
Probably two answers. One is that's interpretation. The way the master settlement is set out, it's 85-15. So 85% for opioid remediation and 15% for other substances. The reality view probably is that when you use the funds to, say, improve capacity and do other things that assist the drug treatment providers for purposes of opioid remediation, you perhaps collaterally benefit the same treatment providers who are treating folks for crystal methamphetamine and other things, because you're expanding their capacity and generally, and you're reducing bottlenecks and things of that nature. So if you're mindful of it, there could be a collateral benefit to the other users even though you're focusing the money as required under the master settlement agreement, if that makes sense.
Yes. Okay. I assume that you're going to continue to work through the Hawaii Community Foundation, or do you plan on using another sort of funding vehicle, like the way that we do with the Tobacco Cessation Fund?
Yeah, yes. Let me just clarify too. So the way that the master settlement agreement is set out, there's treatment on one side of it, and then there's prevention on the other. Treatment for folks who already have substance use disorders and as I just talked about, the 85-15 split, but prevention, arguably, since you cannot anticipate who will develop substance use disorders, opioid use disorders, if you're talking about prevention in young people, then theoretically the money could be used more diversely than not just focusing on opioids, if that makes sense.
Yes.
And in terms of providers, so this is actually, I've only been in the position for like 6 weeks. I did work at the public defender's office, do criminal justice and defense with many folks who have substance use disorders. I'm very familiar with the subject area. It's complex. There are so many different facets of this process, and so it's not just one nonprofit to just hand them the money and say, you know, please fix things. There's everything from criminal justice to nonprofits to treatment, aftercare, and just the list goes on. So it's a complex problem, and it's going to require interaction with a lot of partners.
Thank you.
Yeah.
Thank you. Thank you very much. Okay, any other questions? Otherwise, let's move on to the next measure, HB 2346, relating to manslaughter. This measure amends the offense of manslaughter to include cases where a person knowingly and unlawfully distributes a dangerous drug in any amount and thereby recklessly causes the death of another person who ingested that drug. First up, we have the Attorney General.
Good afternoon, Chair Tarnas, members of the committee, Deputy Attorney General Adrian Daco on behalf of the department. The department is in strong support of this bill. The opioid epidemic, the fentanyl problem is not going away anytime soon. Yes, it's a public health problem, but it'll take a multifaceted approach, including the criminal front, to address the testimony in opposition. I think the Office of the Public Defender made a slippery slope argument that if we have to regulate every single dangerous activity, we would have to regulate MMA fighting, football, baseball, et cetera. What they're asking you is can we have responsible drug users? And that's just simply not realistic. This is a serious problem that requires some kind of solution. We should be past the age of blaming the victim and shaming addicts. You cannot hold the addicts' problem against them, and that's what this bill seeks to close. That's the loophole that this bill seeks to close. With regards to the Drug Policy Forum's concerns, users that are passing the dope around will have immunity under 329 and 329E. So low-level friends among friends will not be prosecuted under this bill. We would ask the committee to move this bill forward. I'd be happy to answer any questions. Thank you.
Thank you. Thanks very much. Next, we have Department of Corrections and Rehabilitations and Support. Next, we have testimony in opposition from the Office of the Public Defender. Welcome. Please proceed.
All right, good afternoon, Chair and members of the committee. My name is William Bento. I'm a Deputy Public Defender. We do oppose the bill, and we've referenced why in our written testimony. And I just wanted to highlight a couple of things. Sitting here listening to the testimony on the previous bill, it came to mind that we are not just talking about illegal substances here. We're talking about dangerous drugs, and however that falls into the definition. So that would include the misuse of pharmaceuticals, I believe, as well. And so, let's think about this. The bill says distribute. It doesn't define what that means, except to go back to 712.12. To go back to distribution as defined for illegal substances. But the bill doesn't stop there. It doesn't say only illegal substances. So technically, you're criminalizing putting into the marketplace legitimate pharmaceuticals that are misused and then distributed, which could in fact cause death. So that's something that I would ask that you take into consideration. The other thing is this: nobody is trying to blame the victim here. Many of our clients are the end users, but it does say in the bill that it's not a defense if the decedent contributed to their own death by voluntarily consuming the dangerous drug. And the reason why we discussed all of this slippery slope is because of the fact that in everything that we do, we always consider the end use. And it's not to say that, we should be protecting drug dealers. No. What we're saying is that people have to be responsible. And otherwise, it's kind of a strict liability situation. And it's not just the guy dealing drugs on the street that we're talking about. Anybody in that chain of distribution could be prosecuted. I've been here for many years, and I've heard many times government officials say certain people will not be prosecuted. I've not seen that come to pass. And so I would say, please take that with some caution. And that's with all due respect to the AG's office and to my colleague back there who's just testified. I've known Mr. Dakwa for years. We've worked together. But I would just ask you to be very cautious in considering the passage of this bill because it does open up a whole new can of worms, so to speak. Thank you.
Thank you very much. Next, we have testimony and support from the County of Hawaii Police Department, testimony and support from the County of Hawaii Office of the Prosecuting Attorney, testimony and support from the Honolulu Police Department. Please proceed.
Hello, Chair, committee members, Captain Andre Peters of the Criminal Investigation Division. We stand on our written testimony in strong support of this bill. Just like the other testifiers, we've seen a recent spike in drug cases or death cases where drugs are involved. I can recall at least of 2 cases that we've had where the user did not know what was in the drugs that they took. And unfortunately, with the rise of fentanyl, that's the cause of the rise of the deaths with drug users. So we strongly support this bill and be able to answer any questions.
Thank you very much. Next, testimony in opposition from the Drug Policy Forum of Hawaii. Mr. Leverance, please proceed.
Aloha, Chair and members. Meta and aloha to everybody on this Valentine's Day. This is the second administration in a row that I've testified against this bill. And even if we were to assume that it's going to be limited only to those who do sales, the reality is that a lot of people engaged in sales are themselves substance users, and they sell to fund their own substance use disorder. That said, the consequences of this statutory language will be very grave from the outset, and that the possible imposition of a 20-year sentence for an accidental overdose that may prove to be fatal is going to thoroughly undermine this state's Good Samaritan law, a very good law, even in comparison to other states, and absolutely deter people from calling 911. This bill runs contrary to the health-focused approach that the state has taken to overdose response and will augur a return to the bad old days when people experiencing overdose were dropped off on a hospital sidewalk or simply left alone to die. The policy forwarded in this bill deeply embodies the wayward sadism of a punitive approach to health issues that, under the decades-long war waged by the criminal legal system against those from under-resourced communities. How did we get here? How did fentanyl come up? You know, it's the iron law of prohibition that I referred to in my testimony at work. More and more supply-side interdiction leads to purer, more potent, and cheaper drugs. It was fentanyl, it's fentanyl today, it's now nitazene. So, we can increase our capacity to do drug tracking through reform of our paraphernalia laws. We can let reagents and spectrometers be used by people who are not aligned with law enforcement. We can also expand behavioral health treatment for people in a non-carceral setting. You know, as I said in my testimony today, we've been at this for 50 years. And what's the result? Just in the past 25 years alone, 1 million overdose deaths. Enough is enough. Defer this bill. And in conclusion, whenever a new sentence is imposed, this bill should be tagged fiscal. The cost of one 20-year sentence, assuming that a person gets full term at a cost of $90,000 per year, is almost $2 million. Those resources are better spent elsewhere. Mahalo.
Thank you very much. Mr. Leverance, you're also listed to present testimony on behalf of the Hawaii Health and Harm Reduction Center. Do you have any further comments you want to make?
Let me just read a short primer from Fair and Just Prosecution on this. Drug-induced homicide prosecutions raise a number of serious concerns, including that they do not alleviate the risk of fatal overdoses, are ineffective as a deterrent to drug use, drug sales, and overdose deaths, can be legally problematic and consume significant resources, and often target family and friends and worsen racial disparities in the system. And as we know, drug law enforcement, along with other enforcement of our criminal laws here, disproportionately impact under-resourced Native Hawaiian and Pacifica communities. Happy Valentine's Day.
Thanks very much for your testimony. Anyone else wishing to testify on this measure before us today? Please introduce yourself and proceed.
Angela Melody Young, testifying on behalf of Kapalama Neighborhood Security Watch. I'm wishing to comment. So the district that I'm from is disproportionately affected by this issue because it's a marginalized and low-income neighborhood. And so we should protect the disproportionately affected communities, Native Hawaiian communities, and Pacific Islanders that are affected by this measure and the subject matter. So deaths caused by illicit drugs, especially fentanyl, are at a historic high. It's why Drug Enforcement Administration agents are committed to protecting Americans and saving lives by pursuing those responsible. They aim to make sure as many drug traffickers involved in those deaths can get an appearance in front of a judge. The poison that is destroying the lives of the loved ones of American citizens is being brought here by criminal drug cartels, said a special agent from the DEA. And DEA's great strength is to take down these networks, and as a result, helping families get justice. DEA might not be able to give closure, but it can facilitate the healing process. The number of deaths due to illicit drugs over the last 3 years has grown by 35%. The chief cause is synthetic opiates, primarily illicit fentanyl. Fentanyl is an opiate which causes a national emergency as declared by the federal HHS. It was an emergency before, it is an emergency now, and the renewal for the declaration of the national emergency was just renewed. And so the stunning increase in deaths has put pressure on all narcotic investigators from DEA to the smallest police departments to make sure the families get justice. Unfortunately, justice is neither quick nor easy and might not come at all. First responders, patrol officers, EMTs, detectives, and medical examiner personnel must work together. How they treat the scene is critical to the future prosecution of the criminals responsible. They should all work together at the scene of the crime to get potential evidence. My proposal,
Please summarize.
yes, is we should prosecute even if it was the deceased's own choice to voluntarily ingest the drug or if the deceased was forced to take the drug. The responsibility lies upon the source of the drug, the supplier, not whether or not it was voluntary. Thank you.
Thank you very much. Anyone else wishing to testify on this measure? Yes, please introduce yourself and proceed.
Hi, aloha kako, everybody. My name is Kekoa Kealoha. I'm here to testify in opposition of the bill. I'm actually from North Kohala, which is your
welcome.
district, sir. I grew up in Niuli'i, a small town across the street from Serapule, and I actually grew up across the street from a couple other people who were very, down the street from people who were also affected by this. I'm a drug addict and I'm in recovery. I got sober on July 24th of 2015. And I oppose this bill because I made my choices. It is clear to me that the only reason that I am in this room and standing in this room and able to talk to you is because I made the decision to get clean and sober. I made the decision to pick up and I had to make the choices that led me here. Now, I'm not trying, please don't misunderstand me. I agree that selling, illegal substances is dangerous. But there is no healing in assigning my own choices to someone else. I could not have found any healing or any source of growth from alleviating my own responsibility in that decision. Since I've gotten sober, I've had the chance to work with marginalized communities, and because I'm in 12-step recovery and constantly surrounded by people who are also getting sober, I am also surrounded by people who have died. And we come from people and communities that are broken. And the policies that are placed in front of us and the reasons why we end up disproportionately affected, why we end up in prisons, and why we end up in these cycles of institutionalism is because we don't have the resources, we don't have the abilities to take care of ourselves before drug use becomes a problem. I would really appreciate an opportunity to give our communities the resources they need to avoid drug addiction instead of jailing them once drug addiction becomes a problem. The people around me, the people that I picked up from were victims of circumstance, just like I was. I don't think that they would be doing these things if they were in places or growing up in places where they had the resources to address all of these socioeconomic problems that are indicative of anybody who's using drugs or selling drugs. And the reality is that the people who are going to be affected by this, the people who are being arrested, are low-level offenders and not the ones who are importing and bringing in drugs who are causing the larger issue. But thank you very much for considering my testimony. Thank you.
Thank you very much. And if you care to submit written testimony, we'd be happy to include that. Absolutely. Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members? I have a question of, I guess let's start with the Attorney General. What is the current penalty for someone who distributes dangerous drugs?
It depends on the amount, but it could be the same level, Class A 20. It could be also
I'm sorry, say again?
It could be a Class A, depending on the amount that's distributed.
Class A felony.
Correct. Depending on the amount that's distributed, it could be a Class A or Class B.
Class A felony is punishable up to 20 years in prison, which is that correct?
Correct.
Okay.
Both are probationable.
Understood, understood. So there already is a significant penalty that is available to judges, depending on the amount, if they choose to assign that penalty to the individual found guilty.
Correct, but it would not cover the circumstance of the end user voluntarily ingesting the drug.
Understood, understood. I'm just talking about current law. What do we have on the books right now?
Correct.
Okay. Okay, let's see. Let me. I wish the Department of Health would have testified on this, because maybe the Attorney General, I could address you. Has there been any discussion between your department and the Department of Health on what is the most effective way to address this issue? In my opinion, is a health issue. Has there been any discussion between your department and the Department of Health?
Not that I'm aware of, but I don't think those are, I don't think it has to be either or. I mean, I can follow up with the Department of Health.
No, I'm just curious. You know, with a governor who's an MD, I would just hope that there would be some consideration to address this very challenging issue through an approach that doesn't repeat what I see as failed drug war policies. And it seems to me that this very punitive approach that is an administration bill does not reflect a harm reduction approach, which I had assumed that a medical doctor would approach. So I would just urge you to reach out to your colleagues in the Department of Health and see if we can come at this difficult problem with a different approach rather than what I view as being an approach that hasn't worked. Sure. And it would only continue to marginalize members of our community rather than address their serious problems. So I would just urge you to do that.
Thank you.
Thank you. Any other questions, members? Representative Ganadin.
To the Office of the Attorney General, good afternoon. Having been on the previous Corrections and Military Veterans Affairs Committee and then practicing law and criminal defense for the last few years, kind of been paying attention to the trajectory of punitive sentences picked up by states as a result of the American drug war. What is the trend here in the state of Hawaii, like with regards to hard drug usage? Is it going up? Is it leveling out after the sort of like high mark of the early 2000s with methamphetamine use?
I don't have hard data for you, but from the perspective of being a prosecutor on the other side, I know we've had cases together. It seems like the trend is let people out because it is being treated as a health issue and the prisons are overpopulated. So let's get more treatment facilities into place and get addicts more treatment that they need and get them out of prison.
Okay.
Yes.
I am still not clear, even though I practice, as to the ways that cases are prosecuted either by the federal government or by the state. So it seems like the larger distributors, the ones who traffic, of course, interstate, they tend to be prosecuted by the federal government. What kind of decision-making does the Office of the Attorney General take into account when whether or not to, I guess, hand something over to the feds with regards to basically being a drug dealer?
Well, I think there's interagency cooperation in place, and we try and figure out where's the biggest bang for our buck. I mean, I don't know what you're looking for in terms of set policy or anything like that in terms of handing cases off.
Yeah, do you have a policy?
I don't believe so.
So
There's cooperation. We confer with our colleagues from different agencies.
It's not based on the amount or, and any other set? It's
Amount, criminal history, count, strength of the evidence, penalties that are available on both sides of the street, things of those natures.
Yeah. So would you say that individuals who are essentially trafficking large amounts of dangerous drugs, they're prosecuted with regularity here in the state of Hawaii?
I don't know what you mean by regularity, but there are drug cases involving drug distribution.
Okay. That's all. Thank you.
Thank you. Any other questions, members? If not, we'll move on. Thank you very much to the testifiers. Next, we have House Bill 2350 relating to arrest by federal officers. This measure authorizes law enforcement officers of the Federal Bureau of Investigation to effect arrests under the Hawaii Penal Code in limited circumstances. First up, we have testimony from the Attorney General. Welcome, Mr. Tom. Please proceed.
Good afternoon, Chair Tarnas, members of the committee, Deputy Attorney General Mark Tom for the department. First off, the department would just like to thank the committee for hearing this bill. This is an administrative package bill, and the department is in strong support of House Bill 2350. So thank you for that. This bill essentially allows law enforcement officers of the Federal Bureau of Investigations, the FBI, to effectuate arrests in limited certain circumstances. Currently, the FBI, as well as state law enforcement, sit on multiple or various task force. Additionally, the FBI provides supports that are granted to them in major events or natural disaster type situations. This bill will allow further collaboration, conferring limited powers proposed in House Bill 2350 will just further assist state and county agencies and further ensure safety for our citizens. So department respectfully requests this committee to pass House Bill 2350. Thank you. We'll be here for questions.
Thank you very much. Next, we have testimony and support from the Department of Law Enforcement. Welcome, Deputy Director Vincent. Please proceed.
Good afternoon, Chair Tarnas. Mike Vincent, Deputy Director for Administration for the Department of Law Enforcement. Chair Tarnas, members of the committee, the department stands in support of this. We have a number of officers that participate on federal task forces. Currently, officers with Immigration Customs Enforcement, Customs Border Patrol, Homeland Security investigations have these authorities, and this bill seeks to expand that to the FBI or Federal Bureau of Investigation officers. With these officers participating with state law enforcement, the ability to exercise arrest and police powers in limited conditions, circumstances, is really important as we continue to engage in these various task force events. Over the years, I've been involved in situations where we've got federal officers coming in. How do we give them the authorities so that they can help our local, whether it's state or city and county law enforcement officers? And this will go a long way to help in that way as these officers come in. Thank you.
Thank you very much. Next, we have testimony from the Office of Public Defender. Welcome. Please proceed.
And good afternoon again, Chair Tarnas and members of the committee. Our office does oppose this bill. We're not trying in any way to limit what the FBI does, but we do feel that when you're on the soil of the state of Hawaii or in the city and county of Honolulu, it should be an HPD officer that makes the arrest when it's necessary. There are certain protections that our Supreme Court has granted to our citizens when they're within our state. Some of those are not followed by the federal government and its law enforcement. And so our concern is that there may be situations in which a citizen of our state, or resident of our state, I should say, is going to be arrested, and there's a choice being made to allow an FBI agent to do it because there may be less protections for that resident. And so that is our concern. Let me just say this. On my way into work this morning, I was driving on Nimitz Highway, and I saw a woman who had been arrested. She was cuffed and sitting on the ground, I guess waiting to be transported. There were, I believe, 5 HPD officers there for this one person who was arrested. Now, I don't know the circumstances, and I don't know why they were all there. But I think if the FBI needs to have an HPD officer to come by to effectuate an arrest, it shouldn't be any problem for them to be able to get somebody to come and do that. Thank you.
Thank you very much. Next, we have testimony from the FBI Honolulu Division. In support, testimony in support from the Hawaii County Office of the Prosecuting Attorney. Also testimony in support from the Maui County Department of the Prosecuting Attorney, testimony in support from Victor Ramos, and testimony in opposition from Ryan Willis. Is there anyone else wishing to testify on HB 2350? If not, questions, members. Representative Gannadin, please proceed.
Mr. Tom, with the Office of the, not with the prosecutors anymore, you're with the Office of the Attorney General.
Office of Attorney General.
Yeah, you've been transferred.
Thank you, Rep.
Yeah. Does the FBI effectuate arrests for immigration violations?
I do not know that answer. I can follow up for you with our counterparts with the FBI. Off the top of my head, I do not.
In the bill, it says agents, and in your testimony, special agents of the United States Immigration and Customs Enforcement, Homeland Security investigations. So I know that you practiced many years in criminal court, and you know the colloquy that courts give to defendants regarding their immigration status. Do you think that this will, if we allow FBI agents to effectuate arrests, they could just arrest them after we've already given them a colloquy and told them that they, should plead the fifth, or that they would make decisions differently, knowing that in our state courts, knowing that they could be arrested by the FBI no matter what they say?
I do not know. I don't have an answer for you on that question. I can follow up on it. I can at least note to the committee that at least in section, the section that we are amending, this is 803.16, there already is proper training for FBI agents that if they are allowed under 803.16. So I would assume that at least the proper training and understanding, as the public defender indicated, the Hawaii Constitution and any procedural differences there are with the state U.S. Constitution would be, at least they would be educated properly. But in terms of your question, I can definitely follow up and provide follow-up for the committee.
Let me share my concern.
Yep.
Congress is currently discussing major changes to immigration policy in the United States, including changes to the way we effectuate people who have been burdens of legal permanent residence throughout their lives, what we call dreamers. I am concerned that should we effectuate this policy and then Congress changes its policy regarding dreamers, people who are educated folks who are contributing members to society, FBI could pick them up. Do you think that could happen?
I mean, anything is in the realm of possibility, Representative Gannadin. I don't have a exact answer for you that would or would not happen, but I can follow up and see what I can provide for the committee on potential, what's the likelihood of that happening in situations. Thank you.
Thank you. Other questions? I do have a question, Mr. Tom. You're up. I was just curious, since this is an administration bill and you had lots of time to work on it, was there any discussion within the Attorney General's office about the constitutionality of this measure? I'm referencing the testimony from our public defender saying that this raises constitutional concerns.
I don't believe our department shares the same concern of the constitutional concerns raised by the public defenders, but I can additionally, as mentioned to Rep. Ganadin, I can follow up with our department and see if there's any further concerns based on what was provided in the testimony by the public defenders. But to my knowledge, the department doesn't share the same concerns for constitutional issues.
Because that's usually when I have questions about constitutionality issues, I go to the Attorney General. So I would hope that in your development of this, that certainly would have been considered. So if you could go back and check and see if that's in fact the case, because this does seem to be, at least in the public defender's mind, raising constitutional concerns that, to me, are certainly something that needs to be addressed. Allowing federal agents to make arrests and possibly obtain evidence that would be constitutionally permissible under the federal Constitution, but impermissible under the Hawaii Constitution. Please, if you could check and see if those were considered in developing this administration bill, that'd be great.
Will do, Chair.
Thank you, Mr. Tom. Any other questions, members? If not, thanks very much to the testifiers. Let's move on to the next measure. Relating to firearms reporting, this bill amends annual reporting requirement for the Department of the Attorney General concerning firearms concealed carry licenses. First up, we have testimony from the Attorney General. Welcome. Please proceed.
Good afternoon, Chair Tarnas, Senators Gannigan and Miyake. My name is Julie Ibato. I'm the Administrator for the Crime Prevention Justice Assistance Division with the Department of the Attorney General. You have our testimony in front of you. We do stand in support of this bill. Just to kind of summarize really quick, it is a bill to adjust what was passed last session in creating an annual report for the legislature and the public. What we've done is streamline and fashioned a proposal of what could go in the report that's much doable. It's not going to be as labor intensive, and we think it's, the bottom line is it's just doable. If you have any questions regarding the deletions or the changes that we made to the Act 52 last year, I'm available for questions.
Great, thank you very much. Next, we have testimony and support from the Honolulu Police Department. Please proceed.
Good afternoon. Good afternoon, Chair and committee members. I'm Acting Major Carlene Lau from the Honolulu Police Department. We submitted written testimony. HPD supports the language changes of the annual mandatory report submitted to the Department of the Attorney General, State of Hawaii. The changes that they have proposed provide a clearer method for license to carry data collection across all the counties in the state. I'm here to answer any questions. Thank you.
Thank you very much. And we have testimony in opposition from two individuals, JB and Ryan Willis. Is there anyone else wishing to testify on HB 2351? If not, questions, members? I have a question, Attorney General, Ms. Ibato. After we passed the bill last year into law, I've heard some concern that it's difficult for one county to know what other counties have done in terms of concealed carry licenses. So if an individual has applied for a concealed carry license in one county and the other county doesn't know if it's been rejected, for example. And so is there any, it seems to me that we need some sort of statewide database on concealed carry license. Do you have any insights into that?
Yeah, actually, for that particular question, I don't have any particular insight. I am aware of what was passed in Act 52, and it did omit any kind of statewide database. But in terms of what I could talk about in terms of the annual report and the collection of the data that we're looking to provide to the public, that I can comment on. But something much bigger for information sharing across the 4 or 5 police departments. I'm not in a position to respond.
Okay, thank you very much. If Acting Major Lau, could I ask you the same question? Could you give us any insight into this concern that I've heard about one county not knowing what is going on in another county when it comes to issuing of concealed carry licenses? Do you have any insights into that, or do you share that concern?
That is one of our concerns right now. We are communicating through email right now because we don't have a shared database. And so if there is any questions, we can email one of our counterparts in another county. I guess one of the biggest concerns is that the time it takes to get the results back, because not all departments have like their firearms unit working 24/7. So if there is, say, a question, somebody's stopped on the road by a patrol officer, here in Honolulu, if we're not able to get in touch with somebody from Maui, there could be a delay in getting the results back, whether or not this person is legally licensed to carry.
Okay, all right, well, thanks. That just confirms that there is a concern there, and I appreciate that. We have a data expert here. I wonder if you might be able to, thank you very much, Acting Major Lau. Perhaps could you come up? I'd sure appreciate if you've got any insights into this.
I'm not an expert by no means, sir. My name is Philip Higdon, Administrator for the Hawaii Criminal Justice Data Center. Listening to the testimony, what is going on right now and being developed through HIJUS, Hawaii Integrated Justice Sharing. I may have got that wrong, but it's HIJUS. We spoke about it before. But anyway, that is where the police departments, the information, they'll be able to see the information from the other police departments. Who has a carry concealed permit? My understanding is the permit is the same, so there's no discrepancies from each department. All the information is the same. And through HIJUS, they'll be able to make entry into that system to see those records. Hopefully they helped you out, sir.
That would be a great improvement. You don't have a crystal ball. You don't know how long it's going to take before that'll happen, huh?
Well, they're working on it right now, sir. So development, test, and production, right? I've learned that after for a while. But that is one of the, that is on the agenda for the HIJUS executive group, and they're currently working on that, sir, and have met with with the technical groups of the police departments.
Great. Okay,
Yes, sir.
Thanks for that update. Appreciate it. Any other questions, members? If not, we'll move on. Thank you very much, the testifiers. Next is House Bill 2352. This is relating to law enforcement, clarifies the membership and certain powers and duties of the Law Enforcement Standards Board, and establishes new deadlines for the completion of board responsibilities. First up, we have testimony support from the Attorney General.
Good morning, or good afternoon again, Chair Tarnas, members of the committee. Adrian Daco on behalf of the Department of the Attorney General. In full disclosure, I am also the Vice Chair of the Standards Board as well. We would urge this committee to move this bill forward. It is long overdue. This is similar to the prior iterations that we've submitted, or the board has submitted in 2019, 2020, 2021, 2022. Thank you.
Great, thanks very much. Next, we have testimony support from the Department of Law Enforcement.
Good afternoon, Chair Tarnas, members of the committee. Department of Law Enforcement supports this measure, helping to establish the members of the Law Enforcement Standards Board and actually give some good deadlines for them to work toward. And it's actually coincides with a date that was recommended on another measure being heard later, but we are in support of this. Thank you very much.
Thank you very much. We have testimony in opposition from the State of Hawaii Organization of Police Officers. Testimony in opposition from the or testimony with comments and suggested amendments from the Policing Project at New York University School of Law. And some of the comments are in opposition. And then we have testimony and support from Nicholas Shanyon. Anyone else wishing to testify on HB 2352? If not, questions, members? You want to Representative
Attorney
Gannon.
General.
Thank you, sir.
Good afternoon again, sir. The, SHOPO testified that this is duplicative, that Kalea, which they consider the gold standard for standardizing police officers and the new state agency, already does this work. How do you feel?
If their CALEA standards are already in place, then what's the harm of having this on the books? Hawaii is the only state in the nation apparently that doesn't have statewide standards. So if the standards will meet CALEA, then what's the harm in having it?
Thank you, sir.
And not every law enforcement agency is CALEA certified, so it should be in place.
They're not. They're not. Well, I mean, so that means different counties are under different sorts of certifications.
The counties are CALEA certified.
But then, more broadly speaking, the concept of law enforcement also includes the state, and it includes ACOs, it includes, I guess, we can broaden the idea of law enforcement then.
Correct.
Okay, thank you.
Any other questions, members? If not, thank you. Let's move on. House Bill 2353 relating to the criminal justice data sharing groups. This amends the Criminal Justice Data Sharing Working Group to combine its members and functions with certain members and functions of the Gun Violence and Violent Crimes Commission to increase efficiency and effectiveness and eliminate redundancy. Repeals Chapter 134C, Hawaii Revised Statutes, which established the Gun Violence and Violent Crimes Commission. First up, we have testimony from Mr. Higdon.
Good afternoon, Chair and committee members. My name is Philip Higdon, Administrator with the Hawaii Criminal Justice Data Center. The Department of the Attorney General has submitted written testimony to support, in support of HB 2353. To summarize, the purpose of this bill is to consolidate the Gun Violent and Violent Crimes Commission with the Criminal Justice Data Sharing Working Group by repealing Chapter 134C and amending Act 157 and Session Laws of Hawaii 2023 to expand the scope of the Criminal Justice Data Sharing Working Group. The Gun Violent and Violent Crimes Commission recognizes the overlapping objectives of both groups and believes that consolidating these two groups will accomplish the group's objectives more effectively, efficiency, and eliminate redundancy. Thank you for your time, and I'm available for questions.
Thank you for being here and providing your testimony. Next, we have testimony and support from the Department of Law Enforcement.
Good afternoon, Chair Tarnas, members of the committee. Department of Law Enforcement actually sits on some of these committees and working groups that Phil was talking about. And yeah, we would have meetings and actually just have one meeting, end it, and start the next. And by combining them in the statute, it just makes things a lot easier and a lot cleaner for everybody involved. Thank you.
Okay, thanks very much. Anyone else wishing to testify on HB 2353? If not, questions, members? No? We'll move on. Thanks very much. House Bill 2491, House Draft 1, relating to commercial driver's licenses. This amends existing state law to adopt federal penalties for commercial driver's license violations. First up, we have testimony from the Department of Transportation. Please proceed. Online.
Hi, good afternoon, Chair, Vice Chair, members of the committee. Toby Wakamoto, Department of Transportation. We stand in support of our testimony for House Bill 2491.
Could you highlight why this is a good bill?
Well, so this is needed to comply with federal compliance. I guess our fines weren't the same as what it is in the federal ruling. So we got findings against us from the Federal Motor Carrier Safety Administration. So we just revised it to match the federal schedule there.
That helps. Thanks for that explanation.
No problem. Thank you.
Anyone else wishing to testify on HB 2491, House Draft 1? If not, questions, members? Nope. Okay, we're all set. We're going to move on. Thanks very much. House Bill 2012 relating to electric vehicle parking. This removes the exemption that allowed owners of multiple parking facilities within the state to designate and electrify fewer parking spaces than required in one or more of the properties if the requirement for the total number of aggregate spaces on all of their owned properties was met. This authorizes the counties to adopt ordinances to regulate electric vehicle charging systems for places of public accommodation with fewer than 100 parking spaces. First up, we have testimony from the Hawaii State Energy Office. Next, we have testimony from the Climate Change Mitigation and Adaptation Commission. Testimony, and those are both in support. Also testimony in support from the Kauai County Office of Economic Development. Testimony in opposition from the Retail Merchants of Hawaii. Testimony in support from the Hawaii Electric Vehicle Association. Testimony in opposition from NIAP Hawaii Chapter, Evan Oy.
Hello, Chair, Vice Chair, members of the committee. Evan Oy on behalf of NIAP Hawaii. We stand in opposition to this bill, and we just feel as though the exemption should be maintained in order to maintain the flexibility for property owners to be able to allocate the EV stalls amongst their properties to fit market demand, and not so much be required to be mandated to have a stall. We feel as though mandates are essentially what this would equate to is removing that flexibility, so it would per property become a mandate at that point. So we feel as though that's not really the best course of action, and it'd be more appropriate to be able to allocate this into places of a public accommodation, which the market demand would be able to drive the need for the stalls. So thank you for the opportunity to testify. We'll be available for any questions.
Thank you very much. I just see Tina Yamaki walking in, and if you, I called you earlier. Oh, it's not a problem. I see you here, so please go ahead and testify.
Hello and good afternoon. I'm Tina Yamaki with the Retail Merchants of Hawaii, and we stand opposed to this measure. We understand that 10% of the cars in the state of Hawaii are electric vehicles, and of that majority are on the island of Oahu, and most of them are in the urban area. For us, we're seeing a lot of cars that are coming into our shopping centers to charge their batteries because maybe their apartments don't have it, chargers. We see fights going on, and it's like, if I can't charge my car, you can't either, so I'm going to break the charger. We see a lot of that going on. I live in Mililani, and I go to certain shopping centers a lot. And there's one shopping center that has 3 cars on any given day you're going to be seeing charged there. And 2 of them are Teslas, and we found out those owners live 2 to 3 blocks away from that shopping center, and they charge there because they don't want their electric bill to go up. And we see that with a lot of the students too. We have our testimony on this, but on the neighbor islands, most of the people have chargers in their homes and not necessarily need them in the shopping centers. And it does cost a lot of money. You're looking at a minimum of $10,000 per stall to put them in because of all the expenses associated. It's just not the charger. Thank you.
Thank you very much. We have testimony and support from the Oahu Metropolitan Planning Organization. Testimony and support from 350 Hawaii. Testimony and support from the Hawaiian Electric. Welcome. Please introduce yourself. Proceed.
Taria Macomber for Hawaiian Electric Company. Aloha, Chair, Vice Chair, and members of the committee. Like I said, my name is Taria Macomber. I'm testifying in support of HB 2012. Edited my testimony to directly respond to some of the concerns from NAOP as well as the Retailers Association. So I just wanted to reiterate that this loophole is affecting areas that are currently underserved with charging. So they're in a charging desert. And we not only want to increase the number of stalls, we want to ensure that there's geographic distribution of those stalls. And we really do need predictability and consistency of publicly accessible chargers for EV adoption to scale. So EVs are only 10% of the market today in 2024, but we know there's federal mandates for us to electrify by 2035. I also wanted to add that this piece of legislation is for folks that have over 100 parking stalls. So we're not talking about small businesses having to put in a charger. We're talking about large retailers and strip malls that have a lot of parking, and we want to ensure that that has access to public chargers. The CEC did a study last year, the California Energy Commission, and they said that a ratio of 7 EVs per public charger is needed to support the growing EV market. Hawaii currently has 35 registered EVs per public charger. That's 5 times less than what we need. Installing EV charging does come at a cost to site hosts, we understand that, but there are both state and federal incentives and tax opportunities available, including Hawaii Energy's rebate for installation of charging at commercial properties. Geographic distribution is especially critical for folks that live in multifamily housing. Assuming that folks that live at a home can charge at home is a really big assumption. Some people can't afford to charge at home. Some people lease their homes, so they're not able to put in charging infrastructure. And then we especially want to ensure that folks in affordable housing, low-income housing, townhomes, there's so many different types of multifamily housing that exist, have access to publicly accessible chargers. Lastly, allowing property owners to consolidate EVSE at fewer properties reduces the geographic distribution of EVSE, not just on Oahu, but on our neighboring islands as well. We support HB 2012 because we want to increase access to public charging as well as the geographic distribution of public charging. Thank you.
Thank you very much. We've received written testimony and support from the County of Maui County Council Chair and from Scott Kidd and Ryan Willis. State Energy Office just walked in. Come on up. We have testimony and support from the Hawaii State Energy Office. Please proceed.
Chairs, vice chairs, members of the committee, Chris Junker for the Hawaii State Energy Office. We stand on our written testimony and support and are available for questions.
As I always do in this hearing of this committee, I ask you to provide the highlights of your testimony. Please.
I apologize. Just to reiterate a little bit of what Hiko just provided, we have a deficit in terms of the amount of charging available relative to the total amount of EVs that are in the state. We are one of the top 2 states in terms of adoption on just a per capita basis, and yet we're lagging behind on public EV charging. If we want to keep up pace in order to make our decarbonization goals, we need to make up that gap.
Thank you very much. Appreciate it. Anyone else wishing to testify on House Bill 2012, House Draft 1? Please proceed, introduce yourself and focus on the bill. That'd be great.
Angela Melody Young testifying, wishing to comment. So in support of electric cars, yet not too sure about the logistics of the exemptions. And this act deals with electrifying parking lots, and it provides the county's statutory authority to manage electric cars, charging infrastructures in parking lots with fewer than 100 stalls. And so we must take action and set policies to match health and environmental standards to support electric cars. From the electric power that lights up homes to the cars we drive to work, modern life was built on fossil fuels like coal, oil, and natural gas. But burning toxic fuels creates pollution that leads to early death, heart attacks, respiratory disorders, and asthma. Standard cars runs on...
Could you focus on the bill itself?
Oh, okay. I was just going to give...
I don't need background, just focus on the bill.
Supporting electric cars.
Okay. Thank you very much.
Should I go on?
No, because this is specifically removing the exemption to allow owners of multiple parking facilities to designate fewer, et cetera. So you have specific comments on this bill? Not really. Okay, thank you. Any other testimony on House Bill 2012 HD1? If not, questions, members?
Maki? You know, noting the testimony of the government officials and HECO about the various rebates available to these large shopping centers that they can get to include these things. And also, like, just my own experience traveling around the west coast of the United States, and now, like, new East Coast cities where it's like I just see chargers everywhere. What is the difference between Hawaii and those states? It seems like they're moving along pretty quickly in terms of essentially electrifying transportation.
So a lot of the chargers are not done by private. It's actually like a charging business, like a gas station, but for cars to charge. It's a separate industry type of thing for a lot of them. Here in Hawaii, it's very expensive because we have to ship everything in. So anytime you touch retail, like people think, oh, we're not going to pay for the chargers even though they're X amount of dollars. Well, it's going to be reflected the next time you go and you buy Spam or you want to buy bread and eggs and things like that because we pass that cost down onto the customers somehow. And the other thing is, with everything being electric, you don't hardly see any static boards anymore. Sale this weekend, and it's a paper poster. It's usually some kind of electronic board. All of those things take electricity. So a lot of our transformers as well need to be replaced or upgraded, and that costs a lot of money. And a lot of times the rebates don't pay for all of the cost or most of the cost. It pays for a very small fraction of the cost. We still got to dig up the asphalt, and and the parking spaces are designated how much money it brings in on a daily basis. So when you close the parking lot down and people can't park, you don't get people coming into your stores that day. I mean, we all do that, right? You see the parking lot all bust up. It's like, oh, I'll come back next week, when it's all done. So they lose money too that way.
Do you think that your organization or other large retailers, big ones, could better partner with the government in servicing electric vehicle users the way we are in other states?
Yeah, I think the part of it is that there's so many electric vehicles here in the urban area, but not so much on the neighbor islands or even on like in Wahiawa, Waianae, and Nanakuli and all of those areas. So what we've done is we brought our EV parking spaces into those areas that need it the most and have the most. If these other areas, whether it's the Big Island, Waianae, Wahiawa, wherever, Maui, if we see that there's a need for this, we bring it in. The other thing we're finding out is people are breaking our charging systems, and we do it as a customer service. A lot of times it's free, and somebody got to pay for it. My understanding is the replacement equipment is very expensive, and a lot of times they have to fly somebody in to actually fix it too. It's not as simple as it seems.
Thank you.
And expensive. Thank you.
Thanks very much. Other questions, members? If not, thanks very much to the testifiers. Let's move on to House Bill 1611 relating to law enforcement officers. This requires law enforcement agencies and the Law Enforcement Standards Board to consult the National Decertification Index and ensure reporting of officer misconduct to the index. It requires reporting of certain domestic violence records to the National Decertification Index, notwithstanding any contrary law or court order. First up, we have testimony from the Department of Law Enforcement.
Good afternoon again, Chair
Afternoon.
Tarnas, members of the committee. Department of Law Enforcement supports the bill. We want to thank the prior committee for adopting the recommendations that we had made. The committee did ask that we get with the law enforcement standard boards and come up with a recommended date for implementation, and July 1st, 2026, and that actually coincides with the dates from a prior bill that was heard. But we are in support of this, and we're looking at July 1, 2026 for an implementation date. Thank you.
Thank you very much. Next, we have testimony in opposition from the State of Hawaii Organization of Police Officers, testimony in support from the Policing Project at New York University School of Law, testimony in support from Nicholas Chagnon, Derek Carlin, and Scott Kidd. Is there anyone else wishing to testify on House Bill 1611 HD1? If not, questions, members? Nope. Thanks very much. We'll move on. House Bill 1642 relating to general employee orientation. This allows an employee or the exclusive representative, if applicable, to file a complaint with the Hawaii Labor Relations Board if the employer fails to comply with Section 78-64 Hawaii Revised Statutes relating to general employee orientation. On this measure, we have testimony and support from UPW. Welcome.
Chair Tarnas, members, Kamakana Kaimala, Government Affairs Manager, United Public Workers, UPW. Well, you have our testimony and support. We'd just like to highlight that most of the employer jurisdictions are great at providing the general orientation for newly employed public employees. But for the handful that don't, it becomes critical for us to actually try and find these members to provide them with what their working rights may or may not be. And if an employer chooses not to meet its statutory obligation, there is no mechanism to address that violation. So happy to answer any questions you may have.
Okay, thanks very much. Next, we have testimony and support from the Hawaii Government Employee Association. Come on up.
Good afternoon, Chair, members of the committee. Nui Sabas with Hawaii Government Employee Association, HGEA. We're in strong support of this measure. We consider this measure a housekeeping measure to kind of clarify the appeals process if an employer fails to comply with HRS 7864 or offering a general employee orientation. I just want to add too that here at HGEA we find it very important to meet with a new employee to kind of go over what their rights and benefits are under their contract and stuff. Happy to answer any questions. Mahalo.
Thank you very much. And is there, and then testimony and support from Scott Kidd. Is there anyone else here wishing to testify on House Bill 1642? If not, questions, members? Nope, let's move on. Thanks very much. House Bill 2343 relating to enforcement of orders of wage payment. This broadens enforcement of orders of wage payment violations to allow for certified copies of orders of wage payment violation to be filed in any court of competent jurisdiction. On this measure, we have testimony and support from the Attorney General. Welcome. Thanks for your patience.
Good afternoon, Chair Tarnas, members of the committee. My name is Gurudev Allen. I'm a Deputy Attorney General. We strongly support this administration bill, and it will streamline enforcement of wage payment violation orders by the DLIR by broadening it away just from circuit court right now is where we're required to go. It'll allow us to pursue these claims, which are generally smaller in size, in district court, which we believe is appropriate. And we're available for questions.
Thank you very much. Next, we have testimony and support from Jade Butai, Hawaii Department of Labor and Industrial Relations Director. Welcome, sir. Please proceed.
Good afternoon and happy Valentine's Day, Chair and committee members. Jade Butai for the Department of Labor and Industrial Relations. We stand on our testimony in strong support of this governor's package proposal to allow the Attorney General to file in district court to expedite the collection of wage payment violations. Thank you.
Thank you. And we have testimony and support from Danny Kupchoy, HOEISFPAC. Testimony and support from Scott Kidd. Is there anyone else wishing to testify in HB 2343 HD1? Questions, members? Seeing none, let's move on. Thanks very much to the testifiers. Let's move on to the last bill on our agenda for hearing, HB 2370, relating to the Stadium Authority. This clarifies requirements to establish a quorum to do business and validate acts of the Stadium Authority. First up, we have testimony and support from the Attorney General. Next, we have testimony and support from the Department of Law Enforcement. Next, we have testimony and support from DBED, the Stadium Authority. Welcome.
Good afternoon, Chair and members. I'm Ryan Andrews, here on behalf of the Stadium Authority to express our support for this bill, which essentially is a housekeeping bill that proposes amendments to the Stadium Authority statute to clarify the requirements to establish a quorum to do business and to validate acts of the Stadium Authority. Just for a little background, the Stadium Authority has 11 members in total, 9 who are voting members and 2 who are ex officio non-voting members. The current stadium statute is not specific with its application of non-voting members in establishing quorum. So adoption of this bill will clarify that the majority of the Stadium Authority's currently appointed voting members is required to do business, and a concurrence of the majority of the currently appointed voting members is required to take official action. Having these clear requirements is in the best interest of the department and the public. Thank you for the opportunity to testify, and I'm happy to take questions.
Thank you very much. I apologize to the public. The first two, the Attorney General and Deputy and the Department of Law Enforcement, were providing testimony on a different bill, not this one. So thank you to the Stadium Authority for that testimony. In addition, we have testimony support from the Director of the Department of Business and Economic Development and Tourism. Is there anyone else wishing to testify on HB 2370? If not, questions, members? No? Seeing none? Thanks very much. That concludes the testimony on all of our measures today. Thank you to all the testifiers. We're going to move into decision-making. Okay, first up, we have House Bill 1901, HD1, relating to historic preservation. I think this bill needs more work. Personally, I think we should go back and look at HB 201, HD2, SD1, which is in conference committee, and see if we can improve that one and go with it. In the meantime, I think we need to defer this measure. My recommendation for the committee is to defer HB 1901, HD1. Questions or concerns, members? If not, let's go on. House Bill 1529, HD1, relating to burial councils. This is a concern that it's difficult to find people to serve on the burial councils, and this measure allows greater flexibility for the administration. They can choose to use it or not, so I think it's a good idea to move this bill forward. I would like to recommend we make some amendments, some technical amendments to it, so we'd be passing out an HD2. So recommendation is pass HB 1529 HD1 with amendments. Questions or concerns, members?
I'll be voting with reservations. Thank you.
Thank you. Other questions or concerns? If not, Representative Ganadin for the vote.
Members, the recommendation of the chair is to pass HB 1529 HD1 with an HD2, that is with amendments, noting the excusal of Vice Chair Takayama and the reservations of Representative Souza. Chair votes aye. Representative Evslin? Excused. Myself, I vote aye. Representative Holt? Aye. Representative Ichiyama? Aye. Representative Iligan? Aye. Representative Kong? Aye. Representative Miyake? Aye. Chair, the recommendation is adopted.
Thank you. Next measure, relating to opioid litigation proceeds. At the request of the Health and Homelessness Committee Chair, we're going to move this forward with amendments. I'd like to adopt the Department of Health amendments and the Attorney General amendments, along with technical amendments. It needs a lot of work. I still have questions about it, and I would urge Finance Committee to consider any testimony that will be coming into them to make additional changes, because we need to make sure that these issues are addressed. But I think it's a good start to move it forward with amendments, including the Department of Health amendments, Attorney General amendments, and some additional technical amendments. So my recommendation is to move out HB 2806 HD1 with amendments. Any questions or concerns? Thank you. Representative Ganadin.
Thank you, Chair. $156 million is a lot of money. My concerns have to do with the last few decades of the way different states have used the Tobacco Cessation Fund for all kinds of things that have nothing to do with tobacco cessation. I'm concerned that we don't have adequate safeguards to protect this money to assist the people who it's designed to assist. For those reasons, I'll be voting with reservations, and I appreciate the amendments.
Thank you. Other questions or concerns? Representative
I'm voting
Souza.
with reservations as well. Thank you.
Thank you. Other questions or concerns, members? If not, let me reiterate for Vice Chair Ganadin, Pro Tem. We are going to, my recommendation is to pass out HB 2806 HD1 with amendments. Please proceed.
Thank you. Members, the recommendation of Chair is to pass out HB 2806 with an HT2, that is with amendments noting the excusal of Vice Chair Takayama, the presence of Representative Evelyn, the reservations of myself, the reservations of Representative Souza. Are there any further noes or reservations? Seeing none, Chair, the measure is adopted.
Thank you. Next measure, House Bill 2346, relating to manslaughter. I recommend we defer this measure. I think this this proposal seems to think that harsh drug policy criminalization works, and I don't think it works. I think the administration needs to go back and get the Department of Health to work with the Attorney General to try to come up with a different administrative bill to address the issues of distribution of dangerous drugs, because I don't think this is going to work. Questions or concerns, members? If not, let's move on. Thank you. House Bill 2350, relating to arrest by federal officers. I share the concern from the public defender about possible constitutional conflicts that are raised by allowing FBI agents to effect arrests here in Hawaii. And so I would recommend that we defer this measure. Questions or concerns, members? Representative Ganadin.
Chair, as we were having this hearing, I almost managed to forget about the experience that the state of Hawaii had in 2017 with the then Attorney General Doug Chin in his refusal to comply with the then Trump administration's desire to potentially arrest residents of the state of Hawaii for possible violations of that administration's rules. And I think that this could have been an overreach, that this is going to lead to similar situations. For that reason, I'm totally in support of your deferral.
Thanks for that commentary. Appreciate it. Any other comments about my recommendation to defer? Okay. If not, thanks very much. Moving on to House Bill 2351. I agree with the Attorney General that this is an improvement to make the annual reporting requirements more practical and implementable. So I recommend we move this bill forward with a House Draft 1 to defect the effective date to the year 3000 and make technical amendments. So my recommendation is to pass out HB 2351 with amendments. Questions or concerns, members? If not, Representative Ganadin for the vote.
Members, the recommendation is to pass out HB 2351 with amendments, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the measure is adopted.
Thank you. Next, moving on to House Bill 2352 relating to law enforcement. I recommend that we move this out with amendments, defect the effective date to the year 3000, make some technical amendments, and also that we delete language that would have provided an exemption to a person who entered into employment with the applicable county police department or state department before July 1, 2026, and termination of employment would violate any valid collective bargaining agreement. We take out that language and defect the effective date to year 3000 plus tech amendments. That's my recommendation, HB 2352 with amendments.
Members,
any questions or concerns? If not, Representative Ganadin, please proceed.
Jumping it. Members, the recommendation of Chair is to pass out HB 2352 with amendments, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, the recommendation is adopted.
Thank you. On House Bill 2353 relating to criminal justice data sharing groups, I recommend we move this out with amendments, defect the effective date to year 3000, make some technical amendments, and in addition, on page 12, line 17 to 18, I want to delete the sunset provision of July 1, 2029. I'd like to name this new combined group the Criminal Justice Data Sharing and Research Group, and add language that this group will be codified within the statutes, within Hawaii revised statutes, and adding the language that the Criminal Justice Data Sharing and Research Group will be exempt from Chapter 92 relating to the Sunshine Law. That's my recommendation, HB 2353 with amendments. Questions or concerns, members? If not, Representative Gannon for the vote.
Members, the recommendation of chair is to pass out HB 2353 with amendments noting the excusal of Vice Chair Takayama. Are there any further noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. House Bill 2491, relating to commercial driver's licenses. I recommend we move this out with amendments, and these will be technical amendments. So I'm recommending HB 2491 HD1 with amendments. Questions or concerns, members? If not, Rep. Kennedy, please take the vote.
Members, the recommendation of chair is to pass out HB 2491 with amendments noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. Moving on to House Bill 2012 relating to electric vehicle parking. I recommend we move this out with amendments, technical amendments only. So HB 2012 HD1 with amendments. Questions or concerns, members? Representative Kong.
Well, it behooves whatever entity to create these spaces for these cars to bring them in, but to put it in statute that they don't have the flexibility, I should say, it would be no good, so I'll be voting no.
Understood. Thank you, Representative Kong. Other questions or concerns, members? If not, Representative Gannon for the vote.
Members, the recommendation of chair is to pass out HB 2012 HD1 with amendments noting the excusal of Vice Chair Takayama and no vote of Representative Kong. Are there any further noes or reservations? Noting the reservations of Representative Miyake. Any other noes or reservations? Seeing none, the measure is adopted.
Thank you. Next measure, House Bill 1611 HD1. I recommend we move this out with amendments. I'd like to split the difference between the recommended effective date instead of being what it is currently now, July 1, 24. Department of Law Enforcement wanted July 1, 2026. I'm going to recommend July 1, 2025 for the effective date. In addition, I want to make some additional changes. Section 1, page 1, I'd like to delete the language after the word abused and add, quote, when such abuse results in the suspension or revocation of a law enforcement officer's certification, the Law Enforcement Standards Board should be transparent about sharing that information with other law enforcement agencies. The Law Enforcement Standards Board and law enforcement agencies also should conduct thorough background checks before certifying or hiring a new officer to ensure the officer has not abused their authority in another position. I would like to delete lines 14 to 17 relating to the reporting of domestic violence records. Then on section 2, page 2, amend it by deleting lines 8 to 11 and adding the words, quote, the board shall report to the National Decertification Index each time the board suspends or revokes a law enforcement officer's certification, a law enforcement officer voluntarily relinquishes their certification, a law enforcement officer's board certification lapses, or the board opens a disciplinary investigation of a law enforcement officer. And finally, delete lines 12 to 18 and add the words, starting July 1, 2025, and every 6 months thereafter, the board shall communicate with the International Association of Directors of Law Enforcement Standards and Training, or review the National Decertification Index website, or the website of any successor index, to determine if the National Decertification Index is accepting from the board, law enforcement agencies, or other state and county agencies any information or records apart from those described in subsection B, which I just read. Within 3 months of learning that the National Decertification is accepting any information or records apart from those described in subsection B, the board shall promulgate regulations requiring and providing a process for that additional material to be reported to the National Decertification Index by the board, law enforcement agencies, or any other state and county agencies that possess the information or records. That's my recommendation. And just to let the members know, the reason why I'm making these changes is that when we wrote the bill, I had assumed that the National Decertification Index website could accept information directly from county police departments, and they're not able to do that. And so we had to modify it in order to make this actually something could be implemented. So that's why I'm recommending these changes. So it would be House Bill 1611 HD1 with amendments. Questions or concerns, members? Representative Ganadin.
Chair, I'd like to thank you and your staff for your thorough work in following up with this bill. I think it's fundamentally about accountability. As the state embarks to hire as many as 500 new officers statewide in law enforcement, we need to make sure that those officers are of the highest quality we can find and don't have a previous record from another place. Thank you so much.
Thank you. Other questions or concerns, members? If not, let HB 1611 HD1 with amendments.
Members, the recommendation of chair is to pass out HB 1611 HD1 with amendments, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. House Bill 1642 HD1, I recommend we move it out as is. It already has a defective effective date. Any questions or concerns, members? If not, Representative Ganadin for the vote.
1642.
1642 HD1 as is.
Members, the recommendation of chair is to pass out HB 1642 HD1 as is, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. House Bill 2343 HD1, I recommend we move this out as is. Questions or concerns, members? If not, Rep. Ganadin for the vote.
Members, the recommendation of chair is to pass out HB 2343 HD1 as is, noting the excusal of Representative Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. House Bill 2370 relating to the Stadium Authority, I recommend we move this out with amendments by defecting the effective date to the year 3000. So it would be HB 2370 with amendments. Questions or concerns, members? If not, Rep. Ganadin for the vote.
Members, the recommendation of chair is to pass out HB 2370 with amendments, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. Moving on to three measures that are for decision-making only. We heard them in previous hearings. First up, HB 2064 relating to licensing. When we heard this bill, we had testimony and support from the Department of Education. They deferred to the Department of Law Enforcement for input. Department of Law Enforcement had not submitted testimony at that time. Since then, Department of Law Enforcement has submitted testimony in support. And so I would like to recommend we move this bill out. Oh, thank you very much. You're getting their testimony now distributed to you in support. So my recommendation is to move out HB 2064 with amendments by merely defecting the effective date to the year 3000. So HB 2064 with amendments. Questions or concerns, members? If not, Rep. Ganadin for the vote.
Members, the recommendation of chair is to pass out HB 2064 with amendments, noting the excusal of Vice Chair Takayama. Are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. Next, House Bill 2043 HD1 relating to education. You'll remember, members, this relates to establishing a harm to students registry for all preschools and K through 12 educational institutions within the state that contains information on school employees, contractors, or volunteers for whom, as a result of an investigation, a final finding has been issued that the individual has inflicted harm on a student. I had concerns at the time that the Department of Education's Deputy Attorney Generals had not completely signed off on this because we heard testimony from the Attorney General, another part of the Attorney General, that said that there was some potential concerns, and they had objections to the bill. Since then, the Department of Education has gone back and worked with their Deputy Attorneys General and resolved any of those issues, and they came back with recommended amendments. I will describe the amendments. I'm not going to read them line by line, but what they are, it eliminated the appeal panel and instead are requiring that the institution sending the name and information for inclusion of an employee on the harm to students registry certify that the employee was provided due process. The employee must be given written notice of the institution's decision to transmit the employee's name and information and provide the employee with the opportunity to appeal the institution's decision. How the institution handles the appeal process is up to the institution. The institution will need to provide a certification to the department along with the employee's name and information in order to have the individual on the Harm to Students registry. It also builds in the requirement for the department to rely on the certification and requires the institution to defend and indemnify the department should the employee file a lawsuit or submit a claim. Also included language requiring the department to use the Harm to Students registry before hiring any employee or using the services of any volunteer. The amendments changed the language of institutions, quote, inquiring about a prospective employee and volunteer and whether they are on the Harm to Students registry to, quote, consulting the Harm to Students registry. The amendments removed the reference to the Department of Human Resources Development, exempted the registry from Chapter 92F to attempt to protect the information from private schools, and included in definition of inflicted harm on a student or infliction of harm on a student. The AG's office was concerned that there were references to criminal definitions, and the department does not use the criminal definitions or criminal standards in our cases. So the definition was revised using language from the department's Code of Conduct and the Roles and Responsibilities memo that the superintendent issues each year. Those are, and then there's additional minor technical amendments as well. Sorry for that lengthy description, but it's a lot shorter than reading the language itself. So that's my recommendation. The Department of Education really would like to move forward with this, as do the private schools, in order to make sure that they hire good people. Recommendation to move out HB 2043 HD1 with amendments. Questions or concerns, members? If not, Representative Ganadin for the vote.
Members, the recommendation of chair is to pass out HB 2043 HD1 with amendments. Noting the excusal of Vice Chair Takayama, are there any noes or reservations? Seeing none, Chair, the recommendation is adopted.
Thank you. Final measure, HB 1651 HD1. I recommend we move this out with amendments. This is at the urgent request of the Education Committee Chair in order to address serious incidences of harassment at the Department of Education. I want to tell the members and the public that I have met with the superintendent of the Department of Education and urged him to work with the Attorney General to get better support from the Attorney General so that they can in turn support their employees who are experiencing this harassment. I also presented information to the superintendent about alternative means and provided information or encouraged him to get additional information on who might be more effective individuals to serve papers to individuals who have been harassing their employees so that we can actually get better service. So we're working both angles here, working with the department to get them to move forward, but the education chair wants to move this bill forward to make sure that the legislature remains engaged on this issue. The change I would like to make to this is to delete the section that creates a new offense of harassment of an education worker. I think there's sufficient language in statutes right now that would accomplish what's needed for the department. So recommendation is move out HB 1651 HD1 with amendments. Questions or concerns, members? Representative Ganadin.
Chair, I'm changing my initial no vote to an aye, considering your amendment to delete the new criminal charge. Thank you.
Thank you. Other questions or concerns, members? So again, HB 1651 HD1 with amendments. Rep. Ganadin, please proceed.
Members, the recommendation of chair is to pass HB 1651 HD1 with amendments. Noting the excusal of Vice Chair Takayama, are there any noes or reservations? Seeing none, the recommendation is adopted.
Thank you. There being no further business before this committee, we are adjourned.